Right, it's not me you need to be looking at today, it's this place. Okay, so this is Helmand Tor, because I was in court in Bodmin today, and this place is only 15 minutes away, so I thought I'll have a nice little walk up here anyway, just to show you the sights, because I thought it's a nice place to do a video. Then I thought, what can I actually talk about? So, thanks to Gordon again, in the comments, Gordon said, when do you get a jury? Because, you know, on this Tommy Robinson thing and all the confusion as to whether it's civil or criminal proceedings. So the question is, when do you get a jury? And especially, when, if ever, can you get a jury in a civil case? So I'll pan round so you don't see me tripping over rocks. Well, first of all, obviously, in criminal cases, you get a jury in Crown Court cases. Obviously, in the magistrates' court, it's either 3 lay magistrates assisted by the legal advisor, or it's what's now called a district judge, what we used to call a stipendiary magistrate, because they received a stipend. In other words, they actually got a salary, they got payment for it. They are legally trained because they're lawyers, and as such they don't need the assistance of the legal advisor. But if you go to the Crown Court, then obviously decisions of fact are made by the jury. There are a few exceptions to that, you know, fitness to plead, some issues around admissibility of evidence where the judge is in fact assessing facts in the absence of the jury. That's what we call in this country voir dire. Some people say it means speak truth, some people say it means see the truth. In America they have voir dires, but that's when they do all the jury selection, where they give them the big questionnaires and they ask them all sorts of questions. We don't have that anymore, because we no longer have, oh, this is a lovely view, we no longer have preemptive challenges. In other words, neither the prosecution or the defence can now say, as they used to be able to, actually, we just don't like the look of that juror. So we've got a certain number of challenges. Started off as quite a lot and then eventually got down to 3. But now you can't challenge preemptively. You can challenge for cause. So there may be something like, if it's a high profile case or something, you might ask, you know, has anybody on the jury been affected by this issue, or do they know any of the parties or the witnesses, that sort of thing. But other than that, it's pretty much usually first 12 out of the hat. That's the actual Tor itself, so I'll head over there. That's that Logan stone, the one that rocks. Actually, there's 3 Logan stones up here. This is the most rockable one, but I've never actually managed to get it to rock, but we'll have a go. It used to rock when I used to go up here when I was a kid. Ooh. Right, we are quite a long way up. Yeah, so anyway, that's the Crown Court. So when do you have a right to a Crown Court trial? If you are charged with an offence that is indictable only, in other words, can only be heard in the Crown Court, very serious offences, or some offences, what we call either way offences, can be dealt with summarily in the Magistrates' Court or in the Crown Court. And basically both, if it's to be heard in the Magistrates' Court, the magistrates have to say, yes, we can accept jurisdiction, we can deal with this, our sentencing powers are enough. Although rather bizarrely, if you are convicted in the Magistrates' Court, they think their sentencing powers aren't enough, because they're limited to, you know, 6 months for one offence, 51 weeks for 2 or more offences. They can actually boot up to the Crown Court for sentencing. I'm also a big fan of, you're better off being the least serious case in the Crown Court than the most serious case in the Magistrates' Court, so you may as well elect. Because that's the thing, the magistrates have to say we can deal with it, and you have to say I agree you can deal with it. But if the magistrates say no, it's too serious for us, or they say yes, we can deal with it, but the defendant says, well, I don't care, I want a jury trial, it goes to the Crown Court. So that's fairly straightforward. You also sometimes get juries in inquests, not always. The coroner is entitled to sit without a jury and make their own decision. But, you know, sometimes they will put juries in, especially if there's a wider sort of public interest in the matter, sort of like, you know, Grenfell or something like that. Generally speaking, in an inquest, all the coroner or the jury have to determine is who died, when they died, and what killed them. And also then they have to sort of give a little summary, so like death by misadventure, accidental death, unlawful killing, lawful killing, that sort of thing. There's no actual sort of set standard responses there. You can pretty much say anything you want that sort of explains it. Sometimes though you get what are called narrative verdicts. They're all under the ECHR Article 2 inquests, where they'll actually give a narrative verdict. I mean, there's still this rather strange thing that in an inquest you can't actually say anything that apportions blame or implies somebody is to blame, even though you can set out a narrative that clearly makes it clear whose fault it actually was. But coroners and juries are specifically told, don't start saying, and it was their fault. You can say things like, this is exactly what happened and this is why the person died, and coroners can make all these recommendations to avoid sort of future mishaps. But that's just a throwback to the old days. What about civil proceedings though? Because that's what people came here for. Just pan around again so you can see the nice views. I'll head right to the top because I do love me a trig point. Civil cases now, pretty much the only time you get a jury is either it's a case of malicious prosecution or allegations of fraud where your opposing party, the alleged fraudsters, are a government body. They get juries. Malicious prosecution is an interesting one because obviously normally you would think that's against the police, you know, or the prosecution, the CPS, usually the police, and for that you have to show that you were acquitted and there was no grounds for prosecuting you, and it was actually malice, that they knew there was no grounds for prosecuting you. So the mere fact you are acquitted and the judge might have said there's no case to answer or anything like that doesn't necessarily mean it was a malicious prosecution. But the idea is, because it's sort of the individual versus the state, then it's only right that a jury sits on it. And that's the same thing where it's allegations against a government department, because, you know, even though the judiciary are independent, they are an arm of the state, so it's not right that they judge when the state is involved, despite the fact they do that loads of times. I mean, judicial reviews challenging the sort of actions of the state, isn't it? There's no jury there, it's just a judge, or judges. So they're the only two now. Theoretically, there is a possibility that you could have a jury in a defamation case, but the 2013 Act said it's no longer the case that basically defamation, the starting point is a jury, because that used to be it. I mean, you could still actually have just judge-only trials in defamation, but the parties could say, no, we want a jury. That's gone now, it's not automatic. Now, will we ever see, because it's theoretically possible for there to be a jury trial, but will we ever see one? My guess actually is probably not. I did think Lawrence Fox had a really good argument for a jury trial, and he got knocked back on it, so I'll explain what it was. He was accused of being a racist, and his argument was, well, my actions do not amount to racism, and no regular person would think that. However, the judges use something called the Equal Treatment Bench Book, and that applies the Lawrence test for racism. It's racist if anybody thinks it is. And he said, well, hang on a minute, if you've got to decide I'm racist, basically the other side going, we think you're a racist, then by definition you have to find that I am. But what the judge there said is, well, no, because in defamation we are explicitly told, do not approach this case as lawyers or a judge would, approach it as an ordinary, regular layperson would. So it's just a matter of fact as to whether they would find that basically Mr. Fox's actions amounted to racism. So you had sort of an interesting thing there, that the judge was effectively applying like two different tests in two different scenarios. That's quite a nice view. I'll spin around and walk backwards so you can see all the pretty flowers. And if I sort of move that way, come on, Steven Spielberg's job is safe. There we go. So yeah, he said, no, I will approach this as if I was a layperson. And then in the end, he found that actually it was a matter of fair comment to suggest that based on Mr. Fox's actions, because they were able to run a successful opinion defence, because to run an opinion defence, all you have to show is, first of all, it is actually an opinion, not a statement of fact. I mean, it could be a statement of fact. If you just said Mr. So-and-so is a racist, then it's a statement of fact. But if you say Mr. So-and-so has done all the following, X, Y and Z, I think that in my opinion, that makes him a racist, that's okay. I mean, it has to be, you have to point to the facts you're basing that opinion on. You don't have to give chapter and verse anymore, you used to have to, but now you can just point to the gist of it. Because the idea is that somebody has enough information to look at what you've said based on the evidence and go, well, I think you're talking nonsense. I don't see how you arrive at that conclusion from that. So if you leave people with enough room to make their own mind up and you provide them with enough evidence that they can make their own mind up, then that will usually assist you in showing it's an opinion. Because it has to be an opinion that a reasonable person could come to on those facts. It doesn't have to be an opinion that everybody would agree to. Just one that a reasonable person could agree to. Also, it actually has to be your opinion. You actually have to hold it as an opinion. So it's not just enough to say, well, actually, that could be a reasonable opinion. I personally don't hold it. I'm just saying this because I don't like the guy. Then that would defeat the defence of opinion, although that's very rarely in issue. The only case I can think of where that actually cropped up was Banks and Cadwallader. But there you go. I mean, like I say, so civil proceedings, malicious prosecution. Like I say, you can bring that against not just the police. I mean, I can't talk about it now, but I might have an interesting one coming up on that, and I'll tell you about it later. But also, people have brought malicious prosecutions against the revenue. And also, if somebody falsely issues a winding up petition against your company because of all the consequences like freezing your bank accounts and things like that, because petitioning to wind a company up, it's a public act as much as a personal one, because obviously it brings all the creditors in. In that particular case, they've said, actually, if you bring a winding up petition without good grounds, then you can actually bring a claim for maliciously bringing a winding up petition. And back to the defamation case. I mean, I had one where I thought we might have a punt at the jury, because it was a defamation case that we were counterclaiming for malicious prosecution. I can't go into a lot of details about it. So I thought, oh, actually, well, if we get the jury for the malicious prosecution, rather than like have a judge deciding the claim and the jury deciding the counterclaim, how about the jury decide everything? But that's settled anyway, so never got to test that. But there you go. As always, hope you found that vaguely interesting, vaguely useful, vaguely accurate. Like I say, thanks to Gordon for giving me something to talk about, because literally I parked up at the bottom of the hill and I was walking up going, oh, what can I talk about? But I'll just share the view with you again. Like I was trying to get a bit higher, so I can't actually climb while I've got the selfie stick in my hand. Well, I can, but I just can't climb very successfully. But there you go. It's a lovely spot, that. That's all the old clay mines over there beyond that pyramid. That's the Eden project. You can actually, if you get up right, stand on the trig point, you can actually see both coasts from here. But I think I'll abandon standing on the trig point, quit while I am ahead and not sort of rolling down to the bottom of this tour. And I'll see you next time.